Hello and welcome to this video on attempts. Okay, so this attempts is part of the criminal law specification on paper 1. Now this is a broad concept which needs to be almost attached to other crimes that you might study. So this is not a crime in itself, but crimes you might study: theft, robbery, murder, non-fatal offences. So we're looking at attempted crimes. Now we can have a thinking activity. You should pause after this explanation of the activity and have a little think about the question. Note your answer down before continuing. So, has the defendant committed an offence in this scenario? So the defendant was planning on committing armed robbery from a local post office. He illegally bought a gun. One day he put a gun and a balaclava in his bag. He went into the post office. Just before he was to take the gun out of his bag, he realised the cashier was a friend of his mother's and decided against it. In the meantime, the person he bought the gun from had been caught and informed the police of all his recent customers. The police had been tracking the defendant. As he turned to leave the shop, he was arrested. Is he liable for attempted armed robbery? So pause and have a think, and we'll revisit this in class. Okay, so this video is about attempts. So our objectives for this are to be able to explain the actus reus of an attempt, explain the mens rea of an attempt, describe the problem which arises where the offence of attempted is impossible to commit, and apply the law in attempt to scenario-based questions. Okay, so when considering attempts, we need to consider what attempt is, or what an attempt is. So this is when somebody tries to commit an offence but fails to complete the offence for whatever reason. It may be that they're stopped, it may be that they stop themselves. But in terms of examples, there was a big clue at the beginning of this video. You might have seen a big glass of lemonade. This might bring to mind the case of White, in which the defendant tried to kill his mother, but she died before the poison could take effect. Now of course this is attempted murder, because it was not murder, there was no causation for murder, and indeed there was intent. So we're going to look today at how we build up an attempted offence. Now morally, you should be still guilty of some offence, even if they failed to carry it out. The question is this: at what point have they actually attempted the offence? So this had been legislated on by Parliament, and we find a definition of what an attempt is under section 1 subsection 1 of the Criminal Attempt Act of 1981. And they go on to define it as: if, with the intent to commit an offence to which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the offence. So what we've got then is, in a sense, pointed out in yellow here, what are the two key parts of that definition. The first is the intent to commit the offence, and the second is more than merely preparatory. And this is where it gets a little confusing, and we need to follow case law. Now note, a charge can only be brought when the offence attempted is capable of being tried on indictment, which means either a triable either way offence or an indictable offence. If the offence attempted is triable either way, so for example ABH, GBH, theft, that's fine, or indictable offences like GBH section 18 or murder, then it can be tried as an attempted offence. But that wouldn't be the case then, for example, for battery or assault, so attempted battery or attempted assault, because ultimately they are summary offences. So to make clear what it is we need to do, we need to identify the 4 elements of an attempt. The first is, in problem questions at least, identifying what the attempted offence is. Now sometimes that can be a little sneaky in scenarios, and we need to make sure we pull it out. Sometimes it'll be discreet, and that's absolutely fine, we can address that question then, but nevertheless we still need to identify the attempted offence. We then need to go on to identify the actus reus of that crime, so you do need that underpinning knowledge of the crime attempted. The next thing is, we need to discuss the defendant's actions and the idea that they were more than merely preparatory, which means essentially more than preparing for the crime. And finally, establishing the mens rea for the attempt. So we're going to focus on this first element. Now in the problem question, we need to consider what offence has been attempted. So you need to identify what offence has been attempted. So that it be a property offence, a fatal offence, or a non-fatal offence. Now this is relevant because you need to link the concept of what an attempt is to the offence and to understand then what the mens rea is for that specific offence too. So if it's murder, for example, we know that murder, with the intent, you need intent to cause death or really serious harm. For GBH, intent to cause serious harm. And so we need to make sure we're focused on the offence itself. We need to remind ourselves what the offence is and then sort of add on this attempted element because they've not completed the offence. So of course, identify the actus reus first. So as this is likely to be included in the problem question, it could be that this is part of a few issues. So we know with the larger questions you might have 3 or 4 different content areas in which you need to address. So it could be an offence, an attempt, a defence, and a different offence, for example. So we need to make sure we address attempts as a possibility. So you need to list the actus reus elements for the offence to add context to the attempt. You probably don't need to go into as much detail though. And then we need the absolute crucial point. So we need to identify that the defendant's actions were more than merely preparatory. A nice star there just to emphasise that this is the most important part of attempts and arguably the most difficult to understand. Now the reason it's difficult to understand is because it's not been defined in the Act. Yet we know that the defendant must commit an act which is more than merely preparation for the main crime, i.e. the murder, the theft, the robbery, and so on. Now the difficulty lies in establishing what is merely preparatory and what is more than preparatory. Now we're going to look at Campbell, in which a person was convicted of attempting to rob a post office, and we're going to look at the problems with that. Now it's also, what is merely preparatory? It's unclear. There's no definition within the Act, so again we need to look to case law to understand it. Now in the Attorney General's reference, number 1 of 1992, it was held that the defendant didn't need to perform the last act before the act proper. Now that's a concept here, so the last act before the act proper. So if you need to consider this as a series of acts, and then of course, nor does the person need to reach the point of no return. Now the best way to address this in a problem question is to identify all the steps of the act. Now for example, if I'm going to rob a post office, then I need to do several things. I need to decide to rob a post office. I need to get a weapon, for example if it's armed. I need to travel to the post office. I need then to go in to the post office, and then I need to pull a gun and perhaps produce a note or a threat of some description. Then I need also to get away with the money and leave. So there's many different ways, many different steps. So it might be that, the last act in that case before the act proper, so before I actually take the money, is to pull the gun. Now, what we're saying in this case, the Attorney General's reference number 1 in 1992, is that we don't need to pull a gun to be convicted of attempted robbery. Now in Gulliver, it was held that the defendant must be embarked on the crime proper, i.e. the full offence. So then therefore this act, this attempted act, must be part of the commission of the attempted offence. Now Lord Justice Rowler said in Osborne that to be more than merely preparatory, an act must be done by the defendant on the job. So what we're saying there is doing the crime. And as Lord Diplock said in Stonehouse, the offence must have crossed the Rubicon and burned his boat. So this is a little more extravagant, a different way of putting it. But what Lord Diplock is saying is there's no way back. they're in the commission of the crime that they're stopped, in a sense, is irrelevant. They should be really guilty of a crime anyway. They are criminally liable at this point. Now, it is important to note that only acts immediately connected to the offence could be an attempt. So the question is then, when is an act more than merely preparatory? Well, in summary, when the acts of the defendant are part of a series of events which would form the complete offence if he wasn't interrupted. So at that point where he's been stopped or stops himself, if they hadn't been stopped, would he have committed the offence? And that's really the point in which it's more than merely preparatory, and he's embarked on the crime proper. Now, as ever, it's best to illustrate it through case law. So I'm going to distinguish by showing some cases which show merely preparatory acts, and then we're going to go for more than merely preparatory acts secondary. So these next few cases then are going to discuss cases which show mere preparatory acts. So for example, in Gulliver, a man placed a bet on a certain greyhound. Now, seeing his dog was losing, he tried to interfere with the race in the hope that it would be declared void and all bets would be returned. Now, he was convicted for attempting to steal estate money, but the Court of Appeal quashed his conviction for the attempt from the bookmaker and said that as a matter of law he'd not done enough for the case to go to the jury, i.e. his acts were merely preparatory. He'd not yet embarked on the crime proper. So in this case then, perhaps going a little bit further, trying to actually ask for his money back might have been in the commission of the crime, and that might have been where the attempt occurs. So this was merely preparatory to the crime he tried to commit. In Gades, the defendant was found in the boys' toilets in a school, and he was completely unknown to the school. Now, he ran off after being confronted by a police officer, but his bag was found, which contained a large kitchen knife, rope, and a roll of masking tape. And there was enough evidence as well he'd been hiding in a cubicle. In fact, a can of cider was found. Now, he was charged with attempted false imprisonment and convicted, and he appealed. Now, his appeal was allowed because he wasn't embarked on the crime proper, as he'd not come into contact with any of the boys, despite putting himself in a position to attempt the crime. So this is a good example then of what is merely preparatory, because it's clear that he's prepared for the false imprisonment. He's got a kit, he's in the place, but several steps are needed. So he needs to come into contact with the boy. He needs to try to kidnap the boy. And so at that point he'd be embarked in the crime proper. But at the moment he's waiting to commit the crime, and so therefore he cannot be guilty of the crime, attempted crime. Now in Campbell, a man in disguise who was carrying a gun and a threatening note was stopped just outside the door of a post office he planned to rob. Now this harks back to the scenario at the beginning of this video. Now the Court of Appeal quashed his conviction for attempted robbery, saying his acts could be regarded as merely preparatory until he entered the building. Now he's not entered the building, so he's only preparing the robbery. The moment he set foot could perhaps have been attempted robbery, even if he never did anything with the gun or the note. But in this case, being outside the post office was not enough. It was merely preparatory. So we're going to contrast this now with cases where there was an attempt. So in the Attorney General's reference number 1 of 1992, so we referred to this case earlier. Now the defendant dragged a girl to a shed with the intent of raping her. Now he lowered his trousers and he assaulted the girl, but he didn't rape her. Now notwithstanding there are other offences here, the offence was one of attempted rape. Now the conviction for attempted rape was upheld, and it was held that the defendant doesn't need to perform the last act before the crime proper, nor does he need to have reached the point of no return. So yes, there were steps which could be taken, but indeed he's in a position where he's done almost most of the crime already, and so the reason he was guilty, of course, is that he couldn't rape her for reasons which you can research, but still in this particular case he couldn't do it. It doesn't need to have reached the point of no return or the last act, indeed if there's several steps ready. So this was a largely, I would say, policy-based decision, but it gives us that concept of point of no return is not necessary. Now in Jones, the defendant's partner told him she wanted to end the relationship because she was seeing somebody else. Now the defendant bought a gun, got into a victim's car wearing a crash helmet, he obscured his face and he pointed the victim at the gun at the victim. Now he would have had to do at least 3 more acts, so remove the safety catch, put his finger on the trigger and pull the trigger in order to shoot. Now he was stopped before he could go any further, so the victim grabbed the gun and threw it out of the window, but he was charged with attempted murder. Now his conviction was upheld by the Court of Appeal, and Lord Justice Taylor declined to apply the last act test, said the only question was whether the defendant's acts were more than merely preparatory. So he was in the course of committing the crime and he was stopped, so his conviction for attempted murder was upheld. So despite the fact there were those few steps to make, if he wasn't stopped he would have done it, and so therefore this is the idea of more than merely preparatory. In Boyle and Boyle, the defendants broke the lock and hinge on the door, but they were arrested before they could enter the building. Now the conviction for attempted burglary was affirmed by the Court of Appeal because breaking down the door is quite clearly more than merely preparatory to entry as a trespasser, and that is part of the actus reus for burglary, which is beyond the scope of AQA. But it was the start of the substantive crime, so they'd begun the commission of the crime. Now in Tosti, the defendant intending to burgle premises took oxygen or metal cutting equipment with him and hid it behind a nearby hedge. Now the farmer had seen him do this. He concealed the equipment, but he examined the padlock on the door. He didn't damage the padlock, but he was found guilty of attempted burglary. Now again his appeal was dismissed, so this is one step further back from Boyle and Boyle, yet he was still convicted. And he drove to the scene, concealed the equipment, but was seen by the farmer. He approached the door, examined the lock. There's only one further step, and that's to interfere with the lock, and obviously get in as well, sorry. But in terms of the attempted crime, remember we need to be a little bit further back from completing the crime. Examining the lock with equipment was enough. Now there is a question you need to consider, so why was burglary committed in Boyle and Boyle and Tosti but not Campbell? Well, the idea here is they didn't enter the premises, nor did he interfere with a lock, so that could be arguably the difference here. Indeed, burglary is beyond the scope of the specification. Indeed, Campbell, so we wouldn't look at burglary anyway. In terms of Campbell specifically, so remember this is the post office one, when is the attempt? Well, if he enters and he shows the gun and a note, then this is robbery, not attempted robbery, but robbery. Now if he enters and shows the gun and note, but changes his mind or doesn't get the money, there's no robbery because you haven't got the money, but it's more than preparatory, the embarking on the crime proper, so this would be attempted robbery. If he had the note and gun hidden, but was found to have them afterwards, well, burglary could happen if intent can be proven. Now, we don't study burglary, but if you enter premises as a trespasser with the intent to steal, even if you never attempt to steal anything or take anything, for example, if they're not worth taking, then that is still burglary, so that would be that in that case. And if he doesn't enter the post office, then no attempt has been made. And fundamentally, that is the position with Campbell. Now, in terms of elements of an attempt, then, you should identify the attempted offence, as we've done, identify the actus reus in that crime, and consider whether the defendant's actions were more than merely preparatory by following the case law and the judgments. Finally, we need to establish the mens rea for the attempt. So the mens rea for the attempt, then, is we normally require direct intent, i.e. you can't attempt a crime recklessly. So this was confirmed in Wybrow, in which the defendant wired up his wife's bath and caused her to have an electric shock, and he was convicted of attempted murder. He needed intent to kill. And Lord Goddard said, intention is the principal ingredient of the crime. and so therefore we need direct intent. Impairment, intention is defined in Mohan, and again just clarified that idea that we need direct intent. The defendant aimed the prohibited outcome. Now, case law does suggest that oblique intention, i.e. the Woolen or Nedrig virtual certainty test, will be sufficient. So if you feel that it is only oblique intention, then by all means apply that. But it would tend to be direct intent. Now, recklessness would certainly not be enough. So just to recap, or an example here, the mens rea for murder is intention to kill, of course, GBH. But remember, we have direct intention and oblique intention, or implied express malice. But indeed, the mens rea for attempted murder is only intention to kill. If you intend to cause GBH, then it could be attempted GBH instead. Now that will be a bit difficult because, of course, it could be overlaps with ABH and so on. But of course, we need to be sure we know the mens rea is. Now, the justification for this rule is on public policy grounds, to make sure that we are blameworthy when we need to be, but if there's any doubt as to intent, then we're not convicted. Now, I note conditional attempt will not suffice for this particular, for attempts. We need the intent for the full offence. So we studied easing when we looked at theft and the idea of conditional intent for theft, for dishonesty or intention to permanently deprive. Now, the defendant picked up a lady's bag in a cinema, rifled through it, then put it back without taking anything. Now, there was no evidence that the defendant intended to permanently deprive, so therefore couldn't be guilty of attempted theft. Conditional intent then is not enough. Now, in Husseyn, the defendant and another man was seen hanging around the back of a van when they approached by the police and it ran off. Now, the defendant was convicted of attempted to steal the equipment that was in the van, and the court of appeal quashed this conviction because the defendant only had conditional intent, i.e. he would have stolen something had he had the opportunity, but he wasn't stealing the van, and we didn't know what was in the van. So therefore, the conditional intent idea, he wasn't guilty. Now, the suggestion though here that this judgment would now not be followed. Indeed, the Attorney General's reference numbers 1 and 2 of 1979 tell us that conditional intent will now suffice. So despite the two cases we looked at, this would now be enough. Now, conditional intent, just to reiterate there, conditional intent is the idea of taking something or stealing something or doing something if the conditions were right, i.e. there was something worth taking. Now, Millard and Vernon then, a new case, it was held that recklessness is definitely not enough for the mens rea for attempted criminal damage, again outside of the AQA specification. But in this case, the defendants pushed many times against the fence on a stand at the football ground, and the prosecution said they were trying to break it, and they were convicted of attempted criminal damage because they didn't actually break it, and the Court of Appeal quashed their convictions. Okay, in this case, recklessness was not enough. Now, if we look at Attorney General's reference number 3 of 1992, now the defendant threw a petrol bomb towards the victims, 4 of whom were inside the car, and 2 of whom were outside the pavement outside. Now, it passed over the car and smashed against a nearby wall. The defendant's car then accelerated away. Now, the defendants were charged with attempted arson, being reckless as to whether life was endangered, contrary to Section 1, Subsection 2 of the Criminal Damage Act of 1971. Now, the trial judge ruled that on a charge of attempt, intent to endanger life was required, recklessness was not sufficient. Now, this was referred to the Court of Appeal. Now, the Court of Appeal held that on a charge of attempted aggravating arson, it was sufficient for the Crown to establish a specific intent to cause damage by fire, and the defendant was reckless as to whether life would thereby be endangered. Because if the state of the mind of the defendant was that he intended to damage property and was reckless as to whether life another was endangered, and while in that state of mind he did an act which was more than merely preparatory to the offence, he was guilty of attempting to commit that offence. It wasn't necessary that he intended that the lives of others would be endangered by the damage which he intended. Now that is a very technical issue in terms of the mens rea of criminal damage. What we're saying though is, if there are two parts to an offence, so one intent, one reckless, then so long as you've got one of the parts intended, then you could be guilty of the attempted offence. But realistically, that wouldn't be the case in any problem question in AQA. Now in Pace and Rogers, Lord Justice Davis tells us that as a matter of ordinary language, the expression with intent to commit an offence connotes intent to commit all the elements of the offence. So the last thing we're going to cover is what happens if the defendant attempts to commit a crime, but the crime he intends to commit is impossible to do. So for example, trying to kill somebody who you don't know is already dead. So that is the example I've discussed there. Now the common law position before 1981 was that a defendant could not be guilty of an attempt if the offence was actually impossible to commit. But now, Section 1 subsection 2 of the Criminal Attempts Act of 1981 closed this loophole. They say, a person may be guilty of attempting to commit an offence even though the facts are such that the commission of the offence is impossible. Now this applied in Anderton v Ryan, which was then overruled by a decision in Shivpuri, in which the House of Lords used a practice statement to indicate they had previously applied the law incorrectly. So in Anderton v Ryan, a woman bought a video recorder in a pub for £110, believing it to be stolen. But there was no evidence to show that it had in fact been stolen, and the defendant was charged with attempting to handle stolen goods. Now the reason this came to light was because the house was burgled, and she essentially spewed out that she'd bought this in a pub, thought it was stolen. Now the justices dismissed the charge, but the divisional court allowed the prosecution appeal by way of case stated. On appeal to the House of Lords, the magistrate's decision was restored, so the wording of the section, said Lord Roskill, does compel the conclusion that an erroneous belief in the existence of the facts, which if true, would have made the act a crime, makes the defendant guilty of an attempt to commit that crime. Now Shivpuri, in a sense, will overrule this. The House of Lords used a practice statement. Now the defendant in this case was arrested entering the country, carrying with him a package which he believed contained either heroin or cannabis. In fact, it was dried cabbage, ground dried cabbage, and it was quite harmless. But the defendant was charged with attempting to import a prohibited drug, and his appeal was dismissed by the Court of Appeal. Now the House of Lords took note of widespread criticism of its decision in Anderton v Ryan, in which they made the defendant not guilty the year before, given the Court of Appeal decided in this case. Now, they applied the practice statement to depart from the previous decision. They'd made a mistake and wanted to correct it in this new case. Now, the defendant had clearly intended to commit an offence and had done an act, bringing in a package, which the facts had been, as he believed it to be, the package contained drugs. Now, it would have been more than merely preparatory to that offence. Now, of course, you couldn't convict him of actually bringing in drugs. He didn't do that. But he did intend to, he did prepare to, by bringing a case what he thought was full of drugs. Now his conviction was upheld. So in Shivpuri, the House of Lords set in essence section 1 and 2 and 1.3 of the Act of Relevance, particularly 1.3, in which apart from the subsection, a person's intention would not be regarded as having amounted to an intent to commit an offence. But if the facts of the case as he believed them to be, his intention would be so regarded, then, for the purpose of subsection 1, he shall be regarded as having an intent to commit that offence. Now, remember, intent plus more than merely preparatory act is an attempted crime, and that's why this person was found to be guilty. The combined effect, then, is that person can be guilty even where the offence is impossible to commit. Now, sentencing then, so if found guilty of attempted murder, a defendant can face a punishment of maximum life imprisonment. If found guilty of an attempted indictable crime, so for example GBH or manslaughter, a defendant can face the same penalty as if being tried on indictment for that crime. what we were saying there is, if the maximum is life, then the maximum is still life imprisonment. Now, if found guilty of an attempted crime, which is triable either way, the defendant will be liable on summary conviction and can face a punishment for a summary offence. So it's much less, for example, for theft. Okay, so that is attempts in a nutshell. Thanks for watching.